Hi students, Professor Orenberg here, and welcome to our series on organizational choices. This will be a series of videos covering which type of business association to form and why. And we're going to break this apart into a series of smaller videos to make it a little easier to remember all of the details that are involved in the study of business associations' organizational choices. So let's get started. This series is going to proceed with 6 videos. First, we're going to introduce the process of selecting a business entity by reviewing 7 issues that are going to come up time and time again when deciding what entity to choose. We're then going to discuss the 4 major types of organizational choices: general partnerships, limited partnerships, C corporations, and limited liability companies, in the context of those 7 issues, forming a matrix of effectively 4 entity choices by 7 issues. And then in our 6th video, we're going to summarize everything by briefly noting some alternative organizational choices that can be used for professional groups, and then summarizing the 7 issues across this matrix of 4 types of organizational choices. And in that process, you will learn the differences between the 4 major organizational choices and when to select one or the other for basic business planning purposes. Limited liability companies are sort of the new kid on the block when it comes to business organizations. They've been available since the late 1990s, but really took off more recently as a couple of tax laws changed and as they got more accepted in common practice. There are many ways to create an LLC because they are very, very flexible. That's sort of the design. The purpose of an LLC is to fit a variety of needs, going from small business to venture fund to even a large operating company. So their flexibility is both a blessing and a curse. On the one hand, the fact that they're flexible means they're useful for a great many purposes. On the other hand, they need to be customized. They cannot simply be taken off the rack, so to speak, and assumed to fit a given situation. But there's a lot of room for error here. And so starting with the basic entity choices, as we did in this series, going over partnership and corporation first, is important because we sort of are going to pick the best elements of both as we weave together an LLC. Many students would simply default and say an LLC is the best choice for everything because of its flexibility, but it's not always good to be flexible. For one thing, there's room for error. And if you don't know what you're doing, you can mess up an LLC more easily than another form. Second, it's newer, so we haven't had as much case law to tell us how courts are going to find on certain issues regarding these entity choices. Now we have more certainty around that today, and as a result, I think the LLC is becoming a more established choice. Speaking of establishment of choice, there have been efforts to make uniform the state LLC law. It has not been particularly successful. As you can see here, the Uniform Limited Liability Company Act was first promulgated in 1996. The revised act in 2006 has not been widely adopted. It actually creates even more flexibility. But interesting that the original statute, again, is only from 1996, so this is a pretty recent doctrine in terms of law. The main feature of the 2006 changes are going to be with regards to management. Under the previous 96 agreement, the certificate of organization had to define the LLC as either member managed or manager managed. You had to pick one, sort of check the box. And manager managed functioned more like a corporation. Member managed functioned more like a partnership. And you had to declare that at the inception. Under the RULLCA of 2006, the operating agreement, which is not filed, by the way, is going to determine the member managed or manager managed nature, meaning you don't have to publicly file and state how you're going to run the business. That makes it much easier to change the management structure of the LLCs formed under the more modern statute. In addition, under the original LLC statute, depicted here in white, but from 1996, the LLC could only engage in for-profit business activities. Under the revised statute, LLCs can also engage in non-profit business, and so there is an advent of non-profit limited liability companies as well. And basically it's been a move to just more flexibility, more and more and more flexibility. So under the 2006 statute, you have the maximum flexibility that you do of any business organization if you create a LLC under a 2006 jurisdiction. There are, of course, many other minor changes like streamlining administration or reducing compliance costs and creating consistency across jurisdictions, but that's really more of a specialty conversation. To form an LLC, you can't do it by accident. You have to file an article of organization. The members enter into a private operating agreement. Notice that I selected a different icon here. It's sort of similar to the LLC and shows a webwork of people, but of sort of various sizes and natures. That's the nature of an LLC, is you can really customize it to have a organization like you want. So the articles of organization are going to be a very brief document you file with the state, but it's the operating agreement, which is the document that governs how this business will be run and structured. Once again, we have limited liability, and that's true of all members. There's no concept, like in a general partnership, of a general partner with unlimited liability. So we have members. Everyone's a member. Even managers who are members are only liable up to the amount they invest. Now, managers are liable to members, just like directors are liable to shareholders, and do owe fiduciary duties. In fact, there have been a lot of analogies made between corporate duties and LLC duties. So the managers may owe liability to members, but the members will not have a liability to the outside world, except in the event of what's called veil piercing, which we study in a corporate context, but translates to the LLC context as well. Control rights are going to depend on how we structure the business. Now, again, if we're in a 2006 RULLCA jurisdiction, then we can dictate this in our operating agreement. Previously, and under the 96 jurisdictions, we had to actually stipulate this in the articles of formation that were filed with the state. In that case, we would have to declare the company to be member-managed or manager-managed. A member-managed limited liability company is decentralized, like a partnership. And like a partnership, all the members have equal authority to bind the company in ordinary business matters. They're all agents. In a member-managed LLC, we have a structure like a corporation where we have a board of managers or a manager. The manager makes the day-to-day decisions like a CEO would as the agent of the corporation. The members only participate in major life cycle changes and are not agents of the LLC itself. So we can select the structure that we want based on the goals that we have. If we're looking to have a business that operates more like a partnership, we can set it like a member-managed LLC. If we want it to be managed like a corporation, we would select manager-managed. Some statutes provide for equal sharing. Others provide pro rata rates, meaning in some jurisdictions the default is one partner, one share. In other jurisdictions, it's $1, one share. But in general, we want to address this with our operating agreement. The operating agreement is the binding document that controls how this business is going to be structured, and we're going to want to be careful in drafting the financial rights appropriately there. In general, members cannot demand a distribution. The manager has to approve the distributions. We don't have the same issues with double taxation and LLCs necessarily, because they can be taxed as partnerships more easily than a corporation can. But there are still some situations where the LLC will be taxed, and there may be reasons for distributions to be either favored or disfavored on a tax basis. But we're not going to get into the tax law here. Just again, to focus on the financial rights is, once again, it depends. It not only depends on the statute, but it depends really on how the operating agreement is structured. And that's where we want to look. That operating agreement is that core contract between the members that discusses their various rights. Like a corporation, an LLC is generally designed to last forever, although we can set it up to have a end date, like a limited partnership. Once again, flexibility being the watchword here. We can either have it function like a LP and have an end date, or we can have it have perpetual existence. In general, they are set up depending on what is the purpose. So whether or not we would want to have perpetual existence or not depends on whether it's really a fund or whether it's really an operating company. And In general, the withdrawal of a member will not terminate the company. This is the entity theory, not the aggregate theory of associations that applies here. It's seen as a separate entity. And so, depending on the laws of your state, there may be some buyout rights, but generally the withdrawal of a member will not destroy the continuity of the LLC. In general, only the financial interest is transferable. Governance rights, voting rights, kind of like a partnership, are not transferable without consent of all the members. The revised act does change this a bit. It gets very technical at this point, but again, we're sort of an in-between state between partnerships and corporations. Under the revised act, there's a little more flexibility around transfer, but in this particular instance, the transfer of LLC shares or units tends to function more like a partnership than like a corporation. But once again, we can opt out of many of these default rules through changes to the operating agreement. And that operating agreement being that golden contract that binds the parties to its specific terms. Finally, mergers are permitted in most states. The plan of merger, like with a corporation, must be approved by all members and then filed with the state, and that will effectuate the merger of an LLC. So they can be merged just like the other entities can as well. Up next, we're going to talk briefly about alternative organizational choices.